the annual report shows that Romania remains among the states with a high number of pending applications before the court. And I want to ask you, what does this say about the functioning of the Romanian judicial system?
First of all, I want to thank you for this interview. It's, in the current context, absolutely vital that the court, through such interviews, outreach people everywhere in Europe. For my presidency, which started last May, I have identified 3 priorities, which are altogether the grounds of the court's legitimacy: efficiency, visibility, and responsibility. All are linked. And this is part, such interview are part of the needed visibility of the court. And I will do my best with all the other judges to make the court more accessible to the people and to the general public. Thanks a lot for that interview. You're right. Romania is still the 7th place in 2025 concerning the number of pending applications. But in 2024, it was the 4th place. And I want just to stress that there are currently less than 2,500 applications pending before the court vis-à-vis Romania. This remarkable outcome derives from the commitment to case management. This is the crux of efficiency for the court. We have just to work harder to reduce, to decrease the number of pending cases. And I want just to express how important for the trust of the people, the public confidence in the justice, to take such issues seriously. I want to thank all the registry members, more than 750 people working under the authority of the Register of the Court, I own that certainly. And I want also to pay tribute to my colleague and dear friend, Judge Raduletu, the judge elected in respect of Romania, who has decided since the beginning of his mandate just to address the situation of the Romanian cases within the court with a high level of involvement. So yes, there are many pending cases, but less, and it will be continued. It has to be pursued.
Okay, so looking at the distribution by articles in the violation from Romania, we are sanctioned for a wide spectrum of fundamental rights. And I want to ask you, how would you characterize the justice system in Romania based on these statistics? How are things compared to last year's report?
What is true is that there are many provisions of the convention at stake in the Romanian applications decided by the court. It is absolutely confirmed. It has been confirmed this year, and it wasn't the same previously. A wide scope of issues are raised by Romanian applications. And it is meaningful. It is more, if I may, more meaningful as regards the role played by the court than as regards the national situation. It means that the court is working for the effective protection of all human rights for all people. There is no specific issue. And this is true for Romania. This is true for every state. Even if we could identify some, if I may, specific features as regards the Romania cases. And I could be back about detention conditions or property or institution of property, which are particularly a large part of the cases lodged before the court as regards Romania. But this wide scope of the legal issues raised before the court shows how wide is the subsidiary supervision exercised by the court vis-à-vis all the member states. The people are lodging cases about their life, their daily life. And the system built 75 years ago by the founders of the convention asked to the court to take in charge the daily life of the people, of Romanian people, as every other European people. A court for all. It is what everybody should keep in mind. European court is a court for all, dealing with breaches of fair trial proceedings, bringing with the necessity to protect human dignity, respect for life, bringing with some more material issues, I mean, property issues. And this is absolutely emblematic of the architecture of the convention system built just after the Second World
War. So I want to ask you about the number of applications that come from Romania in 2025 compared to 2024. Is there a statistic regarding this? Are there more applications or less applications?
There is in 2025 a decrease of the number of cases lodged before the court in respect of Romania. And I have just the exact number. In 2024, there were around 2,500 cases allocated to a judicial body from Romania, and in 2025, less than 2,000 cases. So to have the big picture in mind, you have just not only just to see that there are less pending cases, but there are also less applications coming from Romania lodged before the court.
Does this mean that there is an improvement in the judicial system from Romania?
It's always difficult to explain why there are such a decrease, or in other situations vis-à-vis other states, an increase. But why it is difficult to explain? Because several different explanations could be made to understand and explain and understand such a trend. One of the main explanation is based on full implementation of subsidiarity principle. The convention system is based on this principle of subsidiarity. What does it mean? It means that the interpretation and the implementation of the convention is a shared responsibility between national authorities and the European Court, which role has to be played in turn and in place after exhaustions of effective domestic remedies. And I will just ask to Judge Radovitu to step in for more technical explanations, but I have a clear idea that both the decrease of the number of pending cases in the Romanian backlog and the decrease of the number of applications lodged before the court from Romania could be understood as the result of the implementation of effective domestic remedies in your legal domestic order. Please, dear Sebastian, if you want just to further elaborate my explanation.
Thank you very much, Matthias. So I would like to stress the fact that, as you said, the general backlog of Romanian applications pending before the court had a decrease of 35% from 2024 to 2025. And it means that Romania is now on the, as the President just said, it is on the 7th place. And in 2024, it was on the 4th place. So from this point of view, even if it is the number, it is still quite big, under 2,500. Comparing with the previous years, it is a remarkable evolution in the good sense. And it is, of course, it is very difficult to explain why we have less applications. We can explain why we dealt with a lot of cases last year, because we tried to organize better the treatment of the cases. But I could say that the principle of subsidiarity started to work better and better concerning the Romanian judicial system and also the Romanian executive. Because, and I can give you two examples from this point of view. In November 2025, we adopted a decision in the case Văscăuțeanu against Romania, where the court recognized that a new case law, a new jurisprudence of the Romanian courts of first instance and of post-sentencing judges became an effective remedy for the detainees. I mean, so far they came directly to our court in order to ask compensation for conditions of detention, and now the court recognized that there is an effective remedy created by Romanian judges by way of jurisprudence. It existed before in the law, but after it became effective due to the work of post-sentencing judges and the courts of first instance across the country. This is the first example. The second example is the case Văleanu and others against Romania concerning the nationalized properties. You know, this is a very, very difficult issue concerning the Romanian law system. And in this case, in Văleanu, we adopted two judgments, one in 2022 on the main, on the substantive part, and one in 2025 in January concerning the Article 41, the way in which we calculate the money to pay to the applicants from this point of view. And we adopted a solution adapted to the Romanian law, but we changed some points. In fact, we said that the evaluation should take into account the situation of the asset in the moment of restitution, not in the moment of the confiscation. And this rule of the established by our court in 2022 and in January 2025 was adopted very quickly by the Constitutional Court in February 2025. So in 1 month, the Constitutional Court issued a decision adopting our point of view, so the case law of the European Court of Human Rights. And in October 2025, the High Court of Cassation and Justice adopted also this, applied this jurisprudence very quickly. So my expectation is that a lot of cases will be solved at national level because of this active approach of the national jurisdiction. And the last point concerning the conditions of detention, in our decision in Văscăuțeanu from November 2025, we praised the Romanian government's efforts to improve the conditions of detention. So we said this specifically, and we expect that they will continue from this point of view. All these efforts of national authorities, judiciary and executive, can contribute to better protect the human rights at national level and to avoid to come here a lot of applications.
And if I may, this is the end to achieve. This is first for the national authorities and notably for the domestic courts to guarantee the rights secured by the convention. So it is absolutely the crux of the shared responsibility, and there are complementary roles played by domestic courts and the European Court. And I take advantage of that point just to underline how important is the dialogue between national courts and the European Court. In the current context, everybody knows that there is somehow a kind of erosion of adhesion of people to the rule of law and humanism approach, humanism-based approach. In such a context, solidarity between churches is needed, not for the churches themselves who are under attack. Not only the system based on the rule of law is called into question, but also churches are under attack. Some churches have been personally targeted for what they have decided professionally, institutionally. I refer to the churches of ICC, which are at the international level subject to sanctions. And it is absolutely concerning. And in such a situation, it's absolutely vital for the well-functioning of democracy that judges are talking together. In that regard, I am pleased just to recall that my first official visit after my election as president of the European Court, I was at the material time president-elect, was with Judge Radoiu in Romania, and when I met the former president of the Constitutional Court. And I'm very happy also to share with you that in May, I will pay an official visit in Romania, still with the national judge, and I will have opportunities to meet and dialogue with not only the Constitutional Court, but also the High Court of Cassation and Justice. And I will have also opportunities to meet national authorities, members of the government, and the president himself. This is really important. The court has to stick with the national reality. We have to talk with domestic church. We have just to explain and clarify our role, but also to listen to what is coming from the member states. The convention system is a ground-up system, and in that regard, the national churches play a role as a bridge between the court and the European scale and the national context. This is really important to keep it in mind. And procedural subsidiarity, necessity, requirement to exhaust effective domestic remedies is one of the elements of this all functioning within the shared responsibility.
One of the main problems with the judicial system in Romania is the excessive length of the proceedings. And I want to ask you, what does the report indicate about the effectiveness of the measures adopted so far? And do we see a better situation than last year's?
On that point also, I will ask just to Judge Radoiu to provide more detailed information.
Concerning this specific issue, I can say that we adopted decision in Brudan versus Romania in 2018, and after this case, I cannot say there is a systemic problem concerning the length of proceedings. It could be, of course, different issues from this point of view, but it doesn't seem to be systemic as before this case. So it depends. It's very case related. We cannot make some general assessments at this time. Maybe later we'll see.
It's always difficult to have general to derive general conclusions from several cases decided by the court. The court has one only legal compass, which is judicial pragmatism. This is a case-by-case approach, and our role is based on the interpretation of the text convention within the context. For sure, after many years, it's possible to have a comprehensive overview of not only the European situation as a whole, but each national situation. But it's really difficult. It's not our usual practice to derive directly from a year of judicial activity a general conclusion. And this is also part of our legitimacy, to remain pragmatic and fully dedicated to adjudications of the cases lodged before the court.
We have in Romania a debate about whether changes to the retirement age and the pensions of the magistrates constitutes an interference with the judicial independence. The government attempt to adopt austerity measures has met the resistance from the Superior Council of Magistrates, which refuses to accept the adjustments to the retirement age and pensions. They're saying that would be an interference with the judicial independence. And I want just, what do you think? How does the pension and the age of retirement interferes with the independence of justice? Is there a link, or what do you think?
I heard that there are really sensitive issues raised in Romania about that question. But I will be really clear. It's not for myself, as president of the court, to make any comment about an ongoing situation. It is absolutely impossible. Let's imagine that some cases in the future will be lodged before the court concerning this specific situation. We have to remain fully independent and impartial to decide these cases. Any kind of comment I can make without any legitimacy to do so will prevent myself and maybe will make the court as an institution in a delicate situation. So I'm sure that you will understand, and the people also, that the self-restraint is absolutely part of the judicial function of the court. About ongoing situation and possible future cases, we have just to be really cautious. On the contrary, I could comment some cases which have been decided, and if I may, I would like to say a few words about Danilet versus Romania, because this is a case decided by the Grand Chamber last December, and this is a landmark case. Beyond the national context in which it has been lodged. As you know, this case concerned the exercise of the right of freedom of expression by judges and prosecutors on internet and social media. And the applicant had been sanctioned for expressing a personal opinion on his Facebook page, accessible to the general public, with thousands and thousands of followers. The main significance of that case is the fine-tuning, the fair balance to be struck between two competing interests, which are really important and which are both pillars of democracy. I mean, pillars or conditions for pluralism and tolerance. In the one hand, the right to freedom of expression of judges. On the other hand, their duty of discretion. By finding a violation of Article 10, in this case, the Grand Chamber of the Court has established some criterion guiding as guidance for every country, every member states, just to manage to strike such a fair balance, and also to prevent any kind of possible abuses against judges or prosecutors. And these criteria are notably procedural guarantees to be respected, but also scrutiny exercised by an independent and impartial body, obligation just to deal with such disciplinary proceedings within the adversarial context, and for sure, so the need for the national authorities to provide well-reasoned decisions to justify the necessity of the disciplinary proceedings and sanctions imposed. This is a landmark judgment because it's not only about the Romanian situation. And this is exactly how we proceed as the Constitutional Court for Human Rights at the European level. The court has to educate a concrete case. By doing so, especially at the crunchable level, the court provides some guidelines which are for the domestic courts and national authorities to implement, with the need to have this shared standard all over Europe. And I'm sure that this judgment will be really helpful in the future, in the next future, when we can expect that the pressures made on the judges and more generally on the rule of law will continue.
So in Romania, the judicial system is facing a crisis of public trust. Over 70% of Romanians say they have little, very little, or no trust at all in the justice system, according to a January poll. And adding to this, one of the ex-vice presidents of the Superior Council of Magistracy said days before that Romania is, I quote, a heaven for criminals. And I want to ask you, how do you see the situation from there, from the court, and is there a problem of perception, or what could you say about this?
I could say nothing about this as president of the court. The court has to adjudicate cases, as I said, and for sure it's not for myself to just to comment or to make some recommendations. It's institutionally impossible. We have an institution avenue, a judicial avenue, for providing preventive guidance to domestic courts. This is under Protocol 16, with the possibility for superior courts to request for advisory opinion on legal issues raised on the occasion of pending cases. But that's all. That's all. Institutions at an institutional level, it's the only way for the court just to, in a certain extent, step in at that stage. So for sure, I won't say anything about what you raised, but I could just add something, not to be just to remain too disappointing. It's about the general situation. All judges, all judiciary are faced in the current situation with an increasing mistrust or distrust from the people. And we have to address that situation. I talk about the erosion of adhesion of people to the rule of law system. And this is really concerning. This is the same everywhere, and not only in Europe. How to embed people, how to deliver an attractive and positive narrative to convince them that it's absolutely not against democracy, against popular sovereignty that the judges are working. Quite the opposite. They are working for the daily life. They are working for their concrete rights. And doing so, judges are working to support democracy. We are part of the democratic system. And this is really challenging, because I'm sure that we will manage. But it demands some innovation. It demands more transparency. It demands also to be ready to report about our activity. It's this responsibility I have identified as a priority, not only for European Court, but for all judiciary. And we are at a turning point. If the anti-judicial populism will manage to convince in a democratic society all people, or a majority of people, that judges are working against their interest, against their will or wishes, the system will collapse, for sure. But I remain confident and optimistic. Through solidarity between judges, through our commitment, all together with the national authorities, by working on a complementary way, we will manage to embed people. Our court is a court for all together. All courts are working for everyone, all together for the benefit of all. And at the end, our shared ideals, peace and justice, will prevail. I'm sure of that.
So, although Russian Federation is no longer a member of the Council, the report shows that the court continues to adjudicate cases related to Russia. And my first question would be, how effective can the court still be in holding accountable a state that doesn't want to cooperate? And also, the 2025 judgment in Ukraine and Netherlands versus Russia is described as unprecedented. And please explain to us how this changes the human rights architecture in Europe.
It's a really important question. Although Russia was expelled from the Council of Europe in 2022, the court made a deliberate and historic choice to retain residual jurisdiction over cases lodged before the 16th of September 2022, and to decide all these pending Russian cases. At that time, around 16 applications were pending against Russia. We worked harder, and less than half remain. And we will continue to work harder. For sure, there's no implementation if the court finds a violation against Russia. There's no implementation of our judgment, which are obligatory and has to be fully implemented under the supervision of the Committee of Ministers. Despite this fact, it's really important for the applicants, but also on a more systemic level for, how to say that, accountability for Russia in the international legal order to proceed as we have decided to proceed. And I want just to say a word about the landmark interstate cases decided by the Grand Chamber last July, Netherlands, Ukraine versus Russia. In these joint judgments, the court found several breaches of the convention as regards what occurred in Ukraine since 2014 and since the beginning of the full-scale invasion of Ukraine in February 2022. And I want to quote what the court declared in finding these several and systemic violations. These actions, suppressing individual freedoms, curtailing political liberties, and displaying a blatant disregard for the rule of law aim to undermine the very fabric of democracy upon which the Council of Europe and its member states are founded. By finding several violations as regards individual rights, the court has not only engaged the responsibility of the respondent state, but also affirmed, in the name of the European public order, that the convention system cannot tolerate the erasure of a member state's legal identity under the pressure of force. These judgments stand a historical record, a bill of accountability, as I said, and a message to future generations. Human dignity cannot be erased, and truth cannot be silenced. This is what derives from these landmark judgments. And I think it's really important to share that in the current situation.